Hey, this is Chris Berry with Castle Wealth Group, and today we're going to talk about the proper approach with trust administration. If you like this information, please make sure to subscribe to our YouTube channel and give us a like, and comment down below if you have any questions.
Christopher Berry is a leading estate attorney and advisor in the area of retirement and legacy planning. He has been featured in publications such as Forbes, Kiplinger's, Crane's Detroit, and more. He's the host of the weekly radio show and podcast, The Chris Berry Show. He's a national thought leader as it relates to retirement and legacy planning, and has authored the Amazon best-selling book, The Caregiver's Legal Guide.
As an estate planning attorney and certified elder law attorney, we help clients set up a lot of trusts. We do quite a few throughout the year, and unfortunately, sometimes people pass away, and we need to assist them with trust administration. And there's a couple key ingredients or key steps that must be taken in terms of trust administration. This fits into the bigger discussion of estate administration. So when someone passes away, there's really four ways that assets can transfer out of someone's name. First would be through joint ownership. Second would be beneficiary designations. Third would be trusts, and we'll spend some time talking about that. But if an asset doesn't pass through joint ownership, beneficiary designation, trust, then it ends up going into probate. And that's something that we probably want to avoid because it's a court process, it's time consuming, and it's costly. So today we're going to focus mostly on trust administration. So let's say you had a loved one that set up a trust, whether a revocable living trust that avoids probate, or maybe they set up a castle trust that avoids probate, protects the beneficiaries, but then also can protect the person who created the trust from creditors, lawsuits, and very importantly, long-term care costs, more specifically nursing home care. Either way, whatever type of trust they created, upon death it becomes irrevocable, meaning no more changes can be made to the trust, meaning the successor trustee or who's in charge of wrapping up the final affairs, they can't change the distribution pattern. They have to follow the rules that were created by that original trust. And so the first thing you need to understand if you are serving the role of a successor trustee is you need to remain impartial. You now owe a fiduciary duty to the other beneficiaries, assuming you're a beneficiary. Even if you're not, you still owe a fiduciary responsibility, meaning you have to act in their best behalf. And really your first step is to get an accounting or inventory of all of the assets that are titled in the name of the trust. We need to figure out what is actually in the trust. And if we have a well-prepared estate planning binder, it should be obvious of which accounts are in the trust or which are not. And then once you've wrapped your arms around creating that inventory of assets in the trust, then we need to work on paying the final expenses, figuring out what bills are hanging out there, wrapping your head around that. And as you're doing this, it's very important to keep good records, keep an accounting. So how much money was there to start? How much money did you pay out in expenses? And then once you're comfortable, all the expenses, taxes, etc. are paid off, then you can start looking at distribution to the beneficiaries. One of the most important things to keep in mind is to communicate with the beneficiaries. So depending on how the trust was written or the rules of the trust, they may be owed an accounting at the end of the year, or they may be owed an accounting only if they request. But either way, one of the biggest mistakes we see is people not communicating with the beneficiaries, let them know what's going on or let them know what the time horizon or timetable is. One of the biggest questions we get is how long should it take? Typically, at the very least, it should take at least a month because we need to make sure there's no bills or other expenses hanging out there. And quite often takes a little bit longer just to gather up all the assets, pay off the bills, and then handle the distributions. And then if there's real estate, a lot of times it can take longer because now we need to clean up the house, sell all the personal property or do an estate sale, and then sell the house. So it could take months if there is real estate involved. But either way, if you have a trust, it's going to run much smoother than relying on a will, which is really only your ticket to the probate courts. Because remember, a will does not avoid probate. Only a trust does, or joint ownership or beneficiary designations. And most people don't want to name their kids jointly to all their accounts and assets. That's a huge mistake, and that's for another video. And then there's problems with beneficiary designations as well. So that's why a lot of people rely on a trust as the focal point of their estate planning and estate administration. So to summarize, in terms of trust administration, the most important thing is you as a successor trustee, you are a fiduciary. You have to follow the terms of the trust. Second, make sure to communicate with all the interested parties and beneficiaries. Third, just understand the process of putting together that inventory, what is actually in the trust trust, paying off any final expenses, having that accounting, and then making distributions to the beneficiaries. Ideally, it should be wrapped up within a year. Otherwise, you'll run into some tax documents that you'll have to fill out on behalf of the trust. So hopefully this was helpful. This has been Chris Berry with Castle Wealth Group. If you like this video, make sure to subscribe to our YouTube channel. Thank you so much. Bye-bye.
Castle Wealth Group has clients across the nation and helps families plan, protect, and preserve what is important by creating a retirement and legacy blueprint.